quite conscious of the fact that a large number of our colleagues are also keen to go back. So I'll try and be as brief as possible. But there are some important issues, so it may take a little time, sir. So the Honorable Minister has made a statement yesterday on the 9th Ministerial Conference of the WTO at Bali. So before I come to the specific clarifications and queries, just a brief point on the manner in which the old adverse agenda of the WTO against developing countries seems to have come back. I say this because Indian agriculture is in a precarious state. You have over 60% of the people dependent on livelihood on agriculture. Agriculture contributes only about 15% to the national GDP. And therefore, compared to the services sector, the manufacturing sector, our agricultural sector is highly vulnerable. And therefore, the national concern for agriculture is legitimate. As far as global distortions in agricultural trade are concerned, these global distortions have never been because of any lack or denial of market access by developing countries. These have essentially been on account of subversion of global agricultural trade on account of high subsidies by the developed countries, particularly the United States and the European Union. The figure which is globally mentioned is over $400 billion of subsidies. If you cut across all the green boxes, the blue box, the amber box, subsidies are concerned. Having said this, sir, just one more comment as an introduction, and then I'll put the queries. On basis of the draft agreement dated 6 December 2013, the original agreement on agriculture, which was entered into in 1994, itself is loaded against the developing countries. It is loaded against the developing countries because the maximum support or subsidy that developing countries are allowed in order to support their farmers is a 10% de minimis. And this 10% de minimis is based on the 1986-88 prices. Now, between the cost of food grains in 1986-88 and 2013, I don't know whether the increase has been 700% or 800%, but it's bound to be in several 100%. But when you calculate 10%, that calculation of 10% ignores substantially this inflation of food grain, and therefore is calculated at the prices of 1986 and 88. Now, on account of this, we have now to look at what the draft agreement at Bali is. And I'll now straight away come to my objections as far as Bali is concerned. So my first objection to the Bali draft agreement, and the clarifications will arise out of that, even though it's an interim measure, it does not indicate what the permanent solution is going to be, and is it going to be different from what the interim decision itself is. What is the substance of what has happened in Bali? Let's take the Indian context. In the Indian context, our agricultural produce is supported by the minimum support price. When it is supported by the MSP, which is through various governmental agencies, it's a government support price. A large part of this is purchased by FCI and other government agencies, and it is going to be used for our food security programs. Now we have the Food Security Act also. The Bali Ministerial is not concerned with our food security program, but it is concerned with the support that we give to our farmer in as much as the government agencies are going to buy from him at support prices. And therefore, the crux of the agreement at Bali is, and that's the direction of the agreement, you are purchasing it by supporting your farmers, and thereby this support that you give to your farmer subverts global trade. That is to say, the subsidized food grain of developed countries, countries like the US, countries like the European Union and other countries which support and which have therefore much cheaper food grain, the effect of subsidy is that the farmer can actually sell below his cost price in subsidized nations because his profits are being subsidized by the subsidy which the treasury of those countries gives him. So once that crosses the Indian borders and enters the Indian state, that's going to be cheaper. So the eventual agenda today, which is back at Bali, is don't subsidize your farmer by this support price system. That's the eventual direction where the agreement is going to take us. Because this will subvert global trade, and the subversion of global trade is that products from other countries of food grain are not going to enter the Indian territory. That is going to be eventually the direction of a permanent solution, and I hope that permanent solution never comes about. Now, the effect of this is going to be that if any such permanent solution comes about, it can have the effect of completely paralyzing the support that we give to our farmers. And most of our subsistence farmers, middle-level farmers, if we don't give them the support, then already the agricultural sector, being in a precarious situation, will become further vulnerable, leading to larger suicides and the collapse of the agricultural sector itself. Now, what is the interim mechanism which we have entered? And I'll urge the Honorable Minister to kindly take the document itself. The interim mechanism that we have entered is, we will take, this is the 10th ministerial, and therefore we are going to wait for 2 more ministerials. That is, a ministerial is normally held every 2 years, if I understand correctly. So 4 years term, and in 4 years we'll eventually have a permanent solution, or try to have a permanent solution. Till then, this interim solution is going to continue. The interim solution is, one, that whichever countries are today giving support which is more than 10% de minimis, based on the 86-88 prices, that will not be challenged for the time being, before the dispute redressal mechanism of the WTO. That's what is being referred to as the peace clause. Now, what is our position today? Under our food security program, we are spending approximately 1,25,000 crores in terms of the food security. Additionally, we have subsidy on fertilizer. States are giving subsidy on transport. States are giving subsidy on power. Now, all these subsidies taken together eventually will have to be 10% of what was the 1986-88 pricing. If they cross that 10% threshold, it will be liable to challenge, but for the next 4 years, the peace clause says it will not be challenged. Now, what is the language of that peace clause? That's clause 2. If the Honorable Minister would take, and I have some difficulty, I hope I am wrong, that we've been outsmarted in the drafting of the agreement itself. Clause 2 says, if you say line, in relation to the support provided for traditional staple food crops in pursuance of public stockholding programs for food security purposes existing as on the date of the decision. Now, my problem arises with this language. The food security programs existing as on the date of the decision. So the peace clause protects only such support to food security programs which were existing as on the 6th of December 2013. Under the Food Security Act, the rollout has not yet begun. If the rollout of the Food Security Act has not begun, is the Food Security Act, which both houses of parliament have legislated, is that outside the protection of the peace clause? Prima facie, the decision whether it is inside the food protection of the peace clause or outside the protection of the peace clause is not an issue which can be decided between the government and me. The language, when it says existing as on the date, it refers to the existing food security program that we have legislated. Over the next few years, we intend to give more security. Is not a food security program which is existing as of the date of the decision. The language could have been for which states have legislatively committed themselves. That is not the language. The language is food security program existing as of date. And if this dispute goes to some tribunal for adjudication internationally, our entire food security program is going to be at the mercy of those people. So my first clarification I seek from the Honorable Minister is, what is the meaning of this word, existing as on the date of the decision? Is it going to cover the entire Food Security Act program? Because that has still not been rolled out. Prima facie, there is a scope you have left in taking an interpretation that that act itself may be out of the scope of the peace clause. Now, if you come to clause 3 itself now provides for a detailed inspection. The detailed inspection I won't read in order to save time, that we have to give various details, they can ask for details, then there are details we have to regularly give, which effectively means that all our food security programs are now open to international inspection. Is that a correct understanding? Now comes my most important objection as far as the Bali document is concerned, and I don't think it leaves any scope for ambiguity. Please turn to clause 4. The peace clause declares peace as far as challenging before the dispute redressal mechanism of the WTO is concerned. That if there is a violation of 10% de minimis, it can't be challenged before the dispute redressal mechanism of the WTO. That's the peace clause, I concede. The peace clause does not cover countervailing duties. The peace clause does not cover anti-circumvention duties. The peace clause does not cover safeguards. Now, clause 4 makes it very clear. And I'm reading clause 4. Any developing member seeking coverage of programs under paragraph 2 shall ensure that stocks procured under such programs do not distort trade or adversely affect food security of other members. Now, this is a part of, not the peace clause, this is a part of anti-circumvention and anti-safeguard, which is an entirely different area other than the peace clause. Now, kindly see the way this is drafted. This means the first objection I have, and I seek the minister's clarification, ordinarily when countervailing or anti-circumvention duties are imposed, the member nation challenging those duties, imposing those duties, has to show that there is a violation which has taken place on account of which he is imposing these duties. Here you have shifted the onus, and the very first 3 words indicate that any developing member seeking coverage of the program under para 2. So if there is a, let us, instead of any developing member, let us use the word India. India is seeking coverage of its food security program under para 2. So India has to ensure that its trade does not distort, that its program does not distort trade and does not adversely affect the food security program of other countries. So the onus of ensuring that there is no distortion and the food security program of some other country is not affected is on India. If I can't ensure that, on all my other exports, whether it is manufactured goods or it is any other exports, we are liable for anti-circumvention duty or any other form of countervailing duty, which means the entire gambit of other exports are going to be adversely affected if these duties are imposed. Now, how is it that it will be alleged that such programs can distort trade? As I indicated, 1,25,000 crores in the Food Security Act, fertilizer subsidy, transport subsidy, power subsidy. Prima facie, in the very first instance, this is going to cross the 10% subsidy. And if it crosses the 10% subsidy, tomorrow any developed country is coming up and saying, well, my goods can't enter your market because of your own food security program. So the scope for challenging and imposing anti-circumvention duty under clause 4 is independent of the peace clause. It always will remain. Similarly, another country can say, you are procuring everything from your farmer. There is nothing left to be imported to my country, exported to my country. So on both counts, other nations are entitled under clause 4, if we violate this, to impose any form of anti-circumvention and safeguards against us. So if we look at the net effect, since the minister was in a celebratory mode in Bali, what is exactly what has happened in Bali? In Bali, instead of putting a permanent ban on this and imposing this 10% limit, they adjourned the whole matter for further decision for 4 years. In the meanwhile, India has had to pay a cost. The cost which we have to pay is, one, we have opened, it is only open for existing programs and not for future programs. B, we have opened ourselves for international inspection. C, we have opened ourselves for anti-circumvention and anti-countervailing duties. And D, we have conceded as far as trade facilitation is concerned. Now, I have no personal difficulty with trade facilitation. It will domestically help us. But please remember, and please confirm whether this is correct, that trade facilitation is a part of the single undertaking. And therefore, trade facilitation had to come when you had market access issues resolved, when you had issues of subsidy reduction which are involved, which have to be resolved. In any case, please don't forget, trade facilitation was added as a WTO issue at the behest of the European Union in 1996. And then in 2003, it was given up. We've now agreed as a cost to bring it back on the agenda. What have we got in return? WTO is a marketing forum. It's a bazaar where you charge for everything that you give and you pay for everything that you get. We have today conceded trade facilitation. What have we got in return? All that we've got is, all this will be decided after 4 years. In the meanwhile, all these constraints which have been put on us. And the biggest cost of Bali, the Honorable Minister will realize, is that whole issue of subsidy reduction is gone. That whole issue of global trade being subverted by them is gone. Instead, the pressure is back on the developing countries as to why you must not now limit your food security programs in countries where 400 million people are living below the poverty line. Therefore, the Honorable Minister may kindly clarify each of these issues that I have raised.